Good afternoon, everyone. My name is Bastiaan Brunungs. I am partner at Lydian, and I'm heading the information governance and data protection / privacy practice at Lydian, together with my team of associates counsel. This webinar is about fair processing notices. I'll give immediately a short overview of this webinar, but first maybe a couple of practical items. First of all, the presentation can be downloaded on your screen at the right hand. You can see the area to download the presentation. Secondly, during the webinar, there will be 2 poll questions. Please answer them to guarantee a valid certificate. In fact, the attendees of this webinar will receive 2 certificates. They will receive 1 certificate from GoToWebinar and then a second one from Lydian that you can use to obtain legal points. Last but not least, if you have any questions, please use, again, at the right-hand side of your screen, the chat function, and we will try to answer your questions either at the end of the webinar or separately by email. So this allows us to start with the contents of this webinar. As I said, a webinar on fair processing notices. I thought it was a good idea to give a short update on fair processing notices, but because we also see there is quite some attention from the supervisory authorities, including the Belgian Data Protection Authority, for the content and the way fair processing notices are written. Let me first give you a short overview of the contents of our webinar today. First of all, I will give you a short introduction about what are fair processing notices. Secondly, a list of the most common mistakes, because I think this will be the guide throughout the presentation. I will try to explain to you a bit more in detail how to avoid those common mistakes. We will, of course, zoom into the information that is mandatory from a legal viewpoint to put in your fair processing notice. We will touch upon the question on whether there are any exceptions to the mandatory information, a number of practical issues. What about consent and what is its relation to fair processing notices on the other hand? The same with respect to legitimate interest, and how do you incorporate legitimate interest into your fair processing notice? And then a number of practical issues, such as how should information exactly be given? That's the subject of Article 12 of the GDPR. When is information due? And then finally, a checklist from our side and some closing remarks. Now, let us start with the beginning. Fair processing notices, what do we talk about? Well, fair processing notices are in fact statements made to the data subject that describe how your company processes personal data. Processes meaning collecting personal data, how it uses personal data, how it stores personal data, how it discloses personal data to third parties, and so on. It should be distinguished from a data protection policy. A data protection policy is more a compliance document which you put, for example, on your website and which explains how your company deals with personal data in general. As I said, this is more a compliance document. This is more directed towards the general public, those who are interested in how your company intends to comply with the GDPR, and it is less distinct to the data subjects themselves. It doesn't necessarily provide all the information that a fair processing notice in the strict sense of the word should contain. Now, fair processing notices are the consequence of a legal requirement. This is described in Article 12, Article 13, and Article 14 of the GDPR, and may be interesting also looking at the latest case law. There is a decision of the Brussels Court of Appeals of 9 October 2019, which clearly says that complying with those obligations of Article 12, 13, and 14 of the GDPR is a result obligation for the data controller. As you probably know, the information that should be given will be different whether you have obtained the information directly from the data subject or indirectly, so through a third party. I will come to that in a moment. And last but not least, non-compliance can give rise to fines, as most of the non-compliance issues under the GDPR. But just to be very factual and very concrete, there have already been, in this short time of application, there have already been two decisions of the Belgian Data Protection Authority, which touched upon the issue of fair processing notices. There is the decision Jubel that you probably are familiar with, where a fine of 15,000 euro was imposed upon a data controller. And then there is the decision 24/2020, where a fine of 50,000 euro was imposed upon the data controller, amongst others, because of failure to comply with Article 12, 13, and 14 of the GDPR on fair processing notices. What are the most common mistakes? First of all, no correspondence with reality. In many cases, the fair processing notice just doesn't correspond to the reality of the data processing by the company. Secondly, too high level, too general, it doesn't provide meaningful information to the data subject. Third issue, use of legalese, so legal terminology that is difficult to understand for the reader and for the data subject, which in many cases is just an individual, is for example a consumer, or is a contact person at a supplier with no particular knowledge of GDPR. Failure to address various types of data subjects and various situations. In many cases, and I will come to that in a minute, in many cases, fair processing notices are too general and do not distinguish enough among the various situations which may occur and the various types of processings that you may have within your company. Forgetting about further processing, there is an obligation in the GDPR that says that when you intend to further process the data beyond the initial purposes, that you will need to inform again your data subjects. This is often forgotten, and as a result, fair processing notices do no longer correspond to the reality of processing. Another issue is vagueness about the recipients, too broad description of recipients, lack of clarity about sensitive data. We'll come to that in a minute. Not informing the data subjects whose data have been obtained through a third party. In many cases, companies receive or collect data from the data subject itself, but they also receive data from third parties. Think about, for example, credit rating agencies. Well, you will need to inform data subjects about the fact that you are receiving data from, for example, credit rating agencies. Not specifying in enough detail the legitimate interests that you rely upon is another common mistake. Vagueness about the legal ground and when it applies, and especially the legal ground for marketing. I will come to that in a minute. And last but not least, not mentioning how changes to your fair processing notices will be communicated to the data subject. Now let's start with the beginning. What information does your fair processing notice need to contain? Well, first of all, you need to identify yourself, your company. You need to provide the contact details of the controller, and if the controller is established outside of the EU, its European representative. And you also need to inform about the contact details of the DPO. One question that is often raised is, do we need to mention the name of the DPO itself? Well, the guidance is such that the name of the DPO does not need to be communicated to the external world. So, for example, in fair processing notices to consumers, it does not need to be mentioned, but it is recommended to provide the name in internal documents. For example, an employee fair processing notice needs to contain the name of the data protection officer. You need to specify the purposes of the processing, which is of course one of the core elements of a fair processing notice. You need to specify the categories of personal data concerned, but this is an obligation that only applies when information is or data is obtained via a third party, so not directly from the data subject. You need to specify the legal basis for the processing, and we'll come to that in a minute. You will need to specify and provide some detail on the legitimate interest. So if you use as a legal basis legitimate interest, you cannot leave it with that. You need to specify what your legitimate interest exactly is. And I will explain this later in this presentation. And then you will need to provide information on the categories of recipients. In principle, as we got recipients, it is recommended to provide as much detail as possible. And some companies go as far as really naming the recipients. Now, the law, the GDPR clearly says that it needs to be categories of recipients, or at least categories of recipients. So you may stick with some more or less broad categories, but of course, the more detail you provide, the more meaningful your privacy notice or your fair processing notice will be. You will also need to provide information on international transfers, and there the information that we see in many fair processing notices is not really sufficient, does not comply with the conditions of the GDPR. What do you need to provide in regard to international transfers? Well, first of all, what countries you are transferring data to, and whether this is inside or outside of the European Union or the European Economic Area. This is a first important element. If you transfer to outside the European Economic Area, you need to say whether or not these countries are covered by an adequacy decision, so whether these are so-called whitelisted countries. If this is not the case, you need to inform the data subject of the appropriate or suitable safeguards that have been put in place, like, for example, standard contractual clauses and so on, or binding corporate rules that have been put in place. And third, and this is often forgotten, in principle, you also need to inform the data subject how these appropriate or suitable safeguards are made available, or where the data subject can obtain a copy of those documents. Something that is also very difficult is the retention period. You will need to provide details on the retention period, or at least the criteria to determine. Where you have within your company a clear data retention policy or a document retention policy, you can refer to that or use that to fill in your, or to complete your fair processing notice. Where it is more difficult, you will need to provide the criteria on the basis of which you will decide on the retention period. it is clear that a mere statement that the data will be kept as long as necessary to fulfill the purposes is not sufficient in this respect. You will also need to provide information on automated decision making. I will come back to that in a minute, will not explain right now. Also added by the GDPR is the fact that whenever you have obtained data from a third party, so not directly from the data subject, you need to inform the data subject of the source of your data. So you need to tell the data subject where you got the data from, and you need also to specify whether those data come from publicly accessible sources, yes or no. And then, as I already touched upon, further processing. Whenever you intend to process the data beyond the intentional or the original purposes of the processing, you will need to provide further information to the data subject on this further processing. Finally, you need to provide a number of informations on the data subject rights. In fact, to be very short, one needs to mention all of the data subject rights. That means the right to access, the right to rectification, erasure of personal data, the right to restrict or object to the processing, the right to data portability, the right to withdrawal of consent, and also the right, and this is specifically mentioned in the GDPR, the right to lodge a complaint with the supervisory authorities. When you collect information from the data subject, you will also need to specify, and usually this is done through asterisks in combination with the privacy policy, you will need to specify whether providing the data is statutory or a contractual requirement. And if this is a requirement, you will need to explain what are the consequences of not providing the data. For example, if this is in the context of online sales, you will need to explain that if certain mandatory information such as the name, the surname, the address, and so on, and some details on payment are not being provided, that you will simply not be able to enter into a contract with the data subject. And then last but not least, you will need to inform the data subject through the fair processing notice also how changes to the fair processing notice will be communicated. And I will come back to that in a moment. Then the question arises, are there any exceptions to this mandatory information? And there a distinction should be drawn between the situation where you collect data from the data subject itself, that's Article 13 of the GDPR, and secondly, the situation where you obtain personal data not from the data subject, but from a third party. That's Article 14 of the GDPR. Well, as regards Article 13 of the GDPR, so the situation where you collect data directly from the data subject, it is clear there is only one exception to not providing the information, and that one exception is where the information has already been received by the data subject. So meaning, if you are in a situation where you can say, in fact, in the past, I already communicated this information to the data subject has already received this information, well, in that case, you will not have to comply again with the requirement or the obligation of Article 13 of the GDPR. But this is basically the only exception to the transparency obligation of Article 13 of the GDPR. If we look at Article 14 of the GDPR, and Article 14 is a situation where data are being collected indirectly, so not through or from the data subject, but from or through a third party. In that case, there are four exceptions. Again, the first exception is when the data subject has already received the information. And of course, this is not a real exception because you will have given this information already once in the past, and so it's not really an exception to the obligation to provide information. The information must be provided to the data subject in any case. There are three other or additional exceptions. The first one is when it concerns confidential data or data that is covered by professional secrecy. In that case, you will not have to provide that particular type of information. Third exception is, and this is typically for the situation where you have received data from a third party on one or more data subjects, and it proves very either impossible or it requires a disproportionate effort to inform the data subject. In that case, you are exempted from providing the information to the data subject directly, but note two things. First of all, this exception is interpreted rather strictly by the various supervisory authorities, including the Belgian Data Protection Authority. They will always try to argue that there are ways to get into contact with the data subject, and there are indeed ways to inform the data subject. It's also true that transparency is one of the basic obligations or one of the big principles of the GDPR. So it will be very difficult to invoke this particular exception on disproportionate effort or impossibility. Secondly, even if you are able to rely upon this exemption, the law, the GDPR, says that you still need to consider other means of informing the data subject, and it refers, amongst others, to public statements or press releases or publication in journals, in the press, to inform, nevertheless, the data subject. And then the fourth exception, but which will in most cases not really be of use to private companies. The fourth exception is where the disclosure is laid down by law, either Belgian law or Union law, so European Union law, and the law has itself provided some appropriate measures to meet the data subject's legitimate interests. You can think about laws or regulations that provide for some mandatory processing of data and also provide for mechanisms to inform the data subject either by law or by regulation about this processing of personal data. There is now a short poll. If you could please answer this poll. This poll will remain open during 40 seconds. The question is, are the information obligations different when the information is collected directly from the data subject or indirectly? And the answer may be yes or no. Thank you for answering this poll. This allows us to go further into the presentation. And the next chapter, we have bundled a number of practical issues that we encounter frequently when reviewing privacy policies or fair processing notices. The first issue that we encounter frequently is legal ground. In many cases, fair processing notices deal with a number of situations and with various purposes. So in a typical situation where you have a fair processing notice, that fair processing notice will, for example, speak about the processing of data for entering into agreements. It will talk about your marketing activities, and so on and so forth. It will talk, for example, also about the processing that you do for compliance reasons. So a number of purposes are bundled in your fair processing notice. And very often what we see is that the fair processing notice is just not clear about the legal ground for each of these purposes. It is very general, very generic. It says we use as legal ground the consent, legal obligation, entering into a contract or taking pre-contractual measures, but it does not specify to which purposes this specific legal grounds relate. So our advice is clearly to be very detailed and to be very clear about this legal ground and to relate this legal ground to each of the purposes that you are mentioning in your fair processing notice. This can be done in text, but what we also frequently see is the use of tables, where you have those typical tables where you mention on the left-hand side the purpose or the activity of processing, and then on the right-hand side, the lawful basis of processing, where you then mention either consent, entering into a contract, taking pre-contractual measures, and so on. Ideally, and that's for clarification towards the data subject, you also link this with the types of data that you're using for each purpose, so that the data subject has a clear view on what are the purposes, what types of data are used for those purposes, and then third, and important of course, what is the legal ground that is being invoked for each of those purposes. A very similar issue is the issue about audiences. As you will probably have noted or yourself already, is that a lot of fair processing notices or privacy policies are directed towards various audiences. It is true that in most cases, companies make a distinction between, on the one hand, those external privacy policies and then the privacy policy for employees. But even if you look at the privacy policy for the external data subjects, even that contains a number of various situations. You can think about your customers or consumers. It can be about suppliers. It can be about prospects. It can be in an insurance context about insureds, about policyholders, possibly about witnesses, about victims which are in contact with your company in the framework of claims handling. So the difficulty in drafting meaningful fair processing notices is really to make this clear what items and what information applies to what audience. And there, indeed, what we see is that in many cases, the information that you should give to the data subject will differ from one case to another, whether this data subject is a consumer, whether it is a prospect, whether it is an insured or a policyholder, and so on. The purposes will differ, the recipients may differ, the legal ground will differ, and so it's recommended in fair processing notices to address each type of data subject separately and to be very clear about each of these items, which may be different for each of the data subjects, namely purposes, recipients, legal ground, and so on. Ideally, in your fair processing notice, you make use of a layered approach, which allows, certainly on the web, which allows data subjects to click through directly to the relevant heading. If the data subject, for example, is a policyholder, that he can click through directly to the information for policyholders, and there he can find for what purposes data of policyholders is being processed, to whom this information is being disclosed, what are the legal grounds, and so on. Another issue that we frequently encounter is special category data and criminal data. As you know, there are specific rules that apply to special category data, such as health-related data, and to criminal data, so data about criminal criminal convictions and criminal facts. Again, our recommendation is to treat this separately from other types of data, and we also see this in most of the fair processing notices that we need to review, but in many cases it does not go far enough. I explain a little bit. If you treat the subject of special category data or criminal data, in most cases, the processing of those types of data will be different from the processing of other types of so-called regular data. So for example, the purposes will be different, and also the recipients will be different, whether there is a transfer or not will be different, and so on. What you need to do in your fair processing notice is to be very clear on how your fair processing notice applies to these special category data or those criminal data. And beware of what we often see, literal interpretation or literal reading by the supervisory authorities, including the Belgian Data Protection Authority. To be very concrete, one of the issues that we often see is that indeed the fair processing notice contains a specific paragraph on special category data and on criminal data, and it goes into the detail of what are the legal grounds for using those data. That's very good, but then the question is, how does the rest of the privacy notice relate to this special category data or criminal data? And often you have other sections of the fair processing notice which deal, for example, with recipients, and then we get the question from, for example, the Belgian Data Protection Authority. Yes, but you mention here that you are processing health-related data, for example, and you do that on these and these, for these and these purposes, and on the basis of these and these legal grounds. But then a little bit further in your fair processing notice, you mention that you are providing the data or disclosing the data to a whole range of recipients, for example, business partners, marketing agencies, and so on. And then the question arises, does this apply to your health-related data? This is very concrete, an example that we have lived, and where it's sometimes very difficult to explain to the data protection authorities how one part of the fair processing notice should be read in conjunction with the parts on special category data and criminal data. So again, think about this and be very detailed, and preferably treat this as a separate subject within your fair processing notice. A similar issue we have encountered with marketing. I think 99% of the fair processing notices directed towards the outer world, so towards consumers or customers and so on, they mention marketing as one of the purposes for the processing of data. Note also that marketing is one of the, and direct marketing is one of the is part of the strategic plan of the Belgian DPA, so they devote a lot of attention to direct marketing and marketing in general. And what we see is often that fair processing notices are, again, too vague, are not sufficiently detailed on direct marketing or on marketing in general, especially on the legal grounds, because of course you are aware of the fact that marketing is being mentioned in the GDPR as a possible legitimate interest for the data controller. But on the other hand, you have all those specific rules on marketing by email, for example, or marketing by telephone, marketing using automated calling machines, and so on, where you often need opt-in from the data subject. And what we see and what we live on a day-to-day basis is that often we get questions from the data protection authorities that say, well, this phrase in the fair processing notice says that you are going to do direct marketing, on the basis of legitimate interest, but can you please explain how you do this then with email marketing? And are you using automated calling machines? And does this apply to all of this also? So again, be very clear about this and devote some more attention, distinguish between the different channels of marketing, so telephone, normal post, fax, electronic post, and so on. And also try to distinguish between, on the one hand, existing customers and, on the other hand, prospects. And you know that, for example, for existing customers, there are some exceptions to the strict opt-in rules for email marketing. On automated individual decisions, including profiling, again, there we face sometimes difficulty in when reviewing fair processing notices. The GDPR says that you should provide 3 items of information. So if you are using automated individual decision making, including profiling, and I think today with big data and with artificial intelligence being more and more used, most companies will be using some form of automated individual decision making or profiling. You need to provide information on 3 items. First of all, you need to provide some information on the logic of the algorithm. So what we refer to as algorithmic transparency. Secondly, you need to provide some information on what is the significance of this decision that is being made automatically about the data subject for the data subject. And third, you need to provide information on the consequences for the data subject. So, for example, a lot of companies in the banking sector are using online systems where people can get a credit approved simply online. Often this is done through algorithms. So algorithms decide on your financial status, decide on whether or not you will receive a credit or not. And if you receive a credit, what will be the interest rate? Well, you will need to provide some information to the data subject on how this algorithm exactly works and what it means, including its consequences, to the data subject. This is a challenge, and I think this will remain a challenge also in the future, especially with the wide use and the broad use of artificial intelligence based systems, where you have, in fact, especially self-learning systems, where you have, in fact, a so-called black box issue. So even those who designed the algorithm do not always know how it works and why it reaches some conclusions. What is the relationship between your fair processing notice on the one hand and consent on the other hand? Well, there are 2 different concepts. The consent is a clear affirmative act establishing freely given, specific, informed, and unambiguous indication of the data subject's agreement to data processing. It is one of the grounds for lawful processing. It must be proven by the controller, but if you look at the conditions for consent, well, consent cannot be part of your fair processing notice. It can be mentioned as a legal ground, but your fair processing notice itself cannot serve as a basis to obtain consent. Why is that? Because the GDPR clearly says that if consent is requested in the context of a written declaration, that this must be separately asked from the other matters, which means it must be in a clearly distinguishable manner. It must be in an intelligible and clearly accessible form, and it must be in clear and plain language. So this is the relation between consent on the one hand and fair processing notices on the other hand. What about legitimate interest? And this is another item where we frequently receive questions, also from the Belgian Data Protection Authority when they review a fair processing notice. As I already explained, in your fair processing notice, you will need to explain on what legal grounds your processing is based, and this may include legitimate interests. Now, legitimate interest is kind of umbrella term for a wide range of interests of the company or possibly of third parties, but it needs to be more concrete. I refer here to a number of examples that are also mentioned in the GDPR. Direct marketing is being mentioned as a possible legitimate interest. Fraud prevention, IT security is certainly a legitimate interest. Now, relying upon legitimate interest is not as simple as it looks like. It's not just mentioning this in your privacy policy or in your fair processing notice. No, in fact, it requires a prior assessment, what we call a legitimate interest assessment, that must be done internally by the company before relying upon legitimate interest for a certain kind of processing. What do you have to treat in this legitimate interest assessment? That must be documented, because this is part of the accountability obligation of the controller. What must be the contents? First of all, you must reflect upon the purpose of the processing. Secondly, you must reflect upon the necessity of the processing for the purposes that you have identified. And thirdly, there must be a balancing exercise. As you know, you can only rely upon legitimate interest when your legitimate interests are not overridden by the rights and freedoms of the data subject. What does this mean, this three-step text, this three-step test? We will just go. First of all, that you have to identify the purpose of the processing. So what is exactly the legitimate interest behind the processing? Why do you want to process the data? What are you trying to achieve? Who is benefiting from the processing? In what way? Are there any wider public benefits to the processing? What would be the impact if you couldn't go ahead? So that's the type of questions that you must answer in this first part of the legitimate interest assessment. In the second part of the legitimate interest assessment, you must assess the necessity of the processing. So if these are your purposes that you just defined, to what extent is the processing that I intend to do necessary to achieve those purposes? So why do you want to process the data? Does the processing actually help to further the interest, that particular interest? Is there a reasonable way to go about it? Is there maybe a less intrusive way to achieve the same result? And then the balancing test is where you in fact balance the interests of that you have identified of the company with, on the other hand, the interests of the data subjects and the rights and freedoms of the data subjects. And there again a number of questions to be answered. What is the nature of your relationship with the individual? Very importantly, what are the expectations of the data subject? Would you be happy to explain to the data subject this kind of processing and for those purposes? Also take into account the nature of the data subject or the type of data subject, especially when there are vulnerable data subjects such as children or other vulnerable persons. Also consider safeguards. What safeguards can you put in place to protect more the rights and freedoms of the data subject? Can you possibly offer an opt-out and so on? And so if you have gone through this legitimate interest assessment and your result is positive, in that case, you can indeed rely upon legitimate interests. What does this mean for the fair processing notice? And there I see that there are often it's not very clear. The guidance also differs from one data protection authority to the other. Some data protection authority says that ideally you would need to include this legitimate interest assessment in your fair processing notice. I think honestly that this goes too far, but what is clear is that you cannot stick in your fair processing notice with just a referral or a reference to legitimate interest. If you rely upon legitimate interest, you need to identify what that legitimate interest consists of, and you need to explain to the data subject how exactly it works. And this is also, and you will also see that in the case law that I mentioned at the very beginning of the Belgian Data Protection Authority, legitimate interest is one of the questions that they raise when reviewing fair processing notices. And they ask questions and they ask you to detail this in more and to provide more information on this legitimate interest. Now then, the question is, how should this information be given? So we have talked about Article 13 on collecting information directly from the data subject, and we have talked about Article 14, information that is being collected not directly from the data subject. Article 12 deals with the information and how exactly it should be given to the data subject. Article 12 says that it should be in writing or electronically, but it can also be orally provided upon the data subject's requests. And then there is a whole range of different requirements on how exactly information should be provided. It should be concise, transparent, it should be intelligible, and it should be easily accessible. What does this mean in practice? For example, use of a reasonable font size so that it is readable for the data subject. It should also be adapted to the target audience. So for example, if you are drafting a privacy notice for children, this should be drafted in another manner than a privacy notice for adults. And also take into account the well, if you are drafting privacy notices for consumers, for example, what is your average consumer? Make sure that he or she understands what is in the fair processing notice. That also means using easily understandable language, making sure that it is easily visible. It should be free of charge. The information cannot be charged. It should also be in the language of the data subject. And again, I refer there to the Jubel decision, where one of the criticisms of the Data Protection Authority was that the information was partly only in English available or not in all languages of the website. So if you're operating a website in 4 languages, make sure that your privacy notice, that your fair processing notices is also in 4 languages. And if possible, make use of a layered approach, meaning that you have an overview, an outline of your full privacy policy, but that the user, the data subject, can easily click through to get to the right information or the information that he or she is looking for. When exactly do you need to provide the information? There again, a distinction is operated between directly collected data and indirectly collected data. If data is collected directly, you should provide the information at the time that you collect the data from the data subject. So that is very simple. If you're processing data that you have collected indirectly, so via third parties, not from the data subject, in that case, the basic rule is that you have to provide the information within reasonable time after obtaining it and maximum within 1 month. But there are 2 specific Rules that apply here too. First of all, if the data is used for communication with the data subject, so you have received, for example, a list of email addresses from a third party, and you are going to use it to communicate with the data subject, well, in that case, you have to provide the information at the time of the first communication. And then the second specific rule is when you have obtained this information from a third party and you are intending to disclose it to a third party, another third party, well, in that case, you must inform the data subject at the latest at the moment of disclosure to the third party. Be aware that whenever there are any changes to your processing operations, to your processing activities, that you will need to inform the data subject. We have already talked about further processing, so processing beyond the initial purposes that were stated, you will need to inform the data subject of this further processing, and think about how this information will be communicated to the data subject. And here, a distinction can be operated between substantive or material changes on the one hand, and on the other hand, more smaller changes. If it concerns a change in processing purpose, of course, the controller identity, the exercise of rights of the data subject, these are material or substantive issues. You should communicate those changes to the data subject. What you should not communicate is, of course, when you are just updating your privacy policy, correcting misspellings, stylistic, grammatical flaws. But if the content doesn't really change, if it doesn't really have a consequence on the rights and freedoms of the data subject, then I think this information should not be directly communicated to the data subject. That brings us to the second poll of today. The question is it mandatory to inform the data subject of any changes to the processing activities? And the possible answers are yes, but only if the changes are substantive or material, or just no. Thank you for completing the poll. I think we have almost reached the end of the presentation. What we have done here at the end is provided you with a short checklist of a number of items that you should consider when reviewing or when updating your private or drafting your fair processing notice. First of all, check whether your company indeed provides a fair processing notice, and especially I know that most companies will have a privacy policy or a fair processing notice, but consider whether this fair processing notice indeed covers all the data subjects about whom you are processing personal data. Secondly, check whether you indeed provide all the mandatory information, and you know that the GDPR has brought a number of changes if you compare it with the Directive 95/46. For example, source of information, data retention period, often forgotten. Check whether any exceptions apply. We have discussed the exceptions, but we have also said that the exceptions mostly apply in case data have been obtained indirectly, so not directly from the data subject, and that most of those exceptions apply only very strictly. Check whether the data subject consented to the collection of data, if you are relying upon consent in your data protection or in your privacy policy or fair processing notice. Check whether you indeed specified the legitimate interest, and this is a point of attention for the Belgian DPA if they have the occasion to review your fair processing notice. Check whether your fair processing notice corresponds with the conditions of Article 12. We have just discussed them. So the conditions on form, on language, on easily accessible, concise, and so on. And then last but not least, check whether you indeed provided the information in a timely manner according to the timing provided in Article 13 or in Article 14 of the GDPR. And then before turning to the questions that we receive, some closing remarks. Often it is said that there is exists a kind of privacy paradox when data subjects are asked about how much they care about their personal data and about how their personal data are being processed. They often say that they care a lot, but on the other hand, you see that they easily accept privacy notices, consent notices, and so on. Does this mean that data subjects do not care about their personal data? Well, no, it is clear that they do care about their personal data, but their attitude, their actual behavior is being determined by a number of phenomena that are extensively being examined in behavioral economics. There's the principle that people are just lazy, so they click through. They don't necessarily read your privacy policy. There's also, and this is very important, I think, for privacy notices, there is the principle of bounded rationality. So if you give too much information to a person, he will not be able to digest this information. He will just click through it. So again, be concise, be clear in your privacy policy, make sure that it is as short as possible. There's also the issue of heuristics, the so-called familiarity heuristic, the rule that people click on a privacy policy and accept a privacy policy because they have done so in the past and nothing bad happened. So they are not really rereading your privacy policy. And also a default inertia by people. People are just not really eager to change default settings, which also, again, it has to do with also laziness, routine, and so on, which makes that people just click through. What does this mean, I think, for your privacy policy? Well, you need to draft fair processing notices so that they are simple, understandable, manageable, and especially that they provide meaningful information. Try as much as possible to apply the so-called KISS principle, keep it simple, stupid, so as simple as possible. And then last but not least, and I think that we see that more and more in literature, that lawyers on the one hand need to work together with designers, possibly graphical designers, to apply what we call then legal design, the application of human-centered design to the world of law, and make sure that by designing and by approaching our privacy policies from a design point of view, that we make them better digestible for data subjects. And I gave you, if you have some time after the this webinar, I gave you one example of a very funny, but at the same time very useful privacy policy, which is not at all the classic privacy policy or fair processing notice of plenty of pages that we see in our daily practice. I see that we came to the end of the webinar. I have a couple of questions. First question, is there a best practice, a checklist or a list of questions to determine if an extra processing activity is yes or no covered by the already existing privacy notice? Sometimes this is a very gray area to see if an update needs to be done or that a new privacy notice needs to be created to inform the data subject. This is indeed correct. I think a checklist, I've mentioned here at the end a number of items that you should look at to determine whether a change is important or material or not. I think similar criteria can be applied here. You need to look, of course, at the purposes, at the recipients, for example, to determine whether or not a certain processing activity is already covered. And it's, of course, a lot of good common sense, I would also say, and looking at it through the eyes of the data subject, because finally, the criterion to be used to determine whether something is inside or outside the scope of your existing fair processing notice is what are the expectations of the data subject. That is the ultimate criterion. So you need to question yourself, if I read this privacy policy and I know that this is a new kind of processing that we are going to do within the company, if I read this privacy policy from a data subject point of view, do I understand or do I expect this new kind of processing to take place? If the answer is yes, then probably it's covered within your existing privacy policy. If you say no, I wouldn't expect that as a data subject after having read this privacy policy, well then the answer is you will need to modify your privacy policy or fair processing notice. And then second question, is legitimate interest not too easy for intra-group transfers? Legitimate interest of a third party, what about groups, i.e. 20 companies in different industries, insurance, banks, headhunters, HR services, and so on? I would like to see the balancing test. Well, indeed, I think the answer is already in the question. For each of the legitimate interests that you apply and that you invoke, you will have to draw up and to document this legitimate interest test, and especially if it's about conglomerates, different companies with different kinds of activities, intra-group transfers for whatever reason or for any reason may be difficult to justify on the basis of legitimate interests. This brings us to the end of this webinar. I hope that you have enjoyed it, that you have learned some things from this webinar. I remind you that you can download the slides of the webinar for future reference. And finally, I would like to thank you for attending this webinar, and we hope that we may see each other hopefully live in the future in a real lunch seminar or at the next opportunity, a next webinar in the future. Thank you very much and have an excellent afternoon.